Okay, well, this is going to be a lecture on the Constitution and business. Uh, Basically, we'll start off with the preamble to the Constitution, which I think is an important place to look for the goals, what they thought they were going to achieve by doing this Constitution. And it also tells us as to who they think they are, or who they think they represent. Starts off by saying, we the people of the United States. So they feel that they are representative of the people of the United States. They know they're not all the people of the United States. They're maybe not a randomly selected group. Most of them were coming from good family backgrounds and were men of success, men who were respected in their communities. We the people of the United States, in order to form a more perfect union. Well, that seems a strange combination of words, right? Perfection cannot be more. You can't get more perfect. Once you reach perfect, that means you've got 100%. It's like trying to say, well, I want to have more than 100%. Well, you can't have more than 100%. You can't get more than 100%. So more perfect union, what did they mean? What were they trying to convey? Well, perhaps they were trying to convey that the current form of government they had in 1789, which was the Confederation, okay, Particles of Confederation, were not perfect. And, you know, they wanted, that it was a kind of union, but it had certain defects. And so they wanted to perfect the union. Let's put it that way. And this is the way they said it. They didn't want to denigrate it too much and call it a name, but they instead adopted this more perfect union. And anyway, to establish justice. Okay, this is one of the goals. To ensure domestic tranquility, so they don't want to be fighting amongst themselves. To establish justice, that means to give to each what he's entitled to, right? And provide for the common defense. Now this is a very important point, because during the Revolution, the troops at Valley Forge starved. General Washington starved, and his officers, Hamilton, they all, you know, all of his men who were with him, they all starved together, including the man who later became the most famous Chief Justice, Justice Marshall. He was there amongst them. And so you had a group of men who were dedicated to the fact that they didn't want to see that happen again. So Washington personally wrote letters, usually drafted by Hamilton, seeking funding from the states, because Congress didn't have any power to raise any money. It couldn't tax. And so seeking funding from the states, and some states gave some money, and others didn't give very much, and some gave none at all. And so they were starving. And he didn't want to see that happen again. So this is probably one of the key reasons why he was a Federalist, in order to provide for a common defense. He knew that that meant that you had to raise money. You can't count on people to fight. You can't fight on people, count on people to bring guns. You need to supply them with bullets. You need to provide them with requisitions so that they won't be running away because of hunger. And so that was a very important point for his seeking a union that was more perfect. He didn't see the Confederation as much because it was heavily dependent upon the states for funding. It had very little powers. It couldn't keep the states from squabbling over commercial interests. And so provide for the common, promote the general welfare. Yes, the general welfare was suffering because states were acting in their self-interest, and therefore they were undermining one another. They weren't acting as a union at all. To secure the blessings of liberty to ourselves and our posterity. So they're looking forward to establishing a government that's going to last. Establish this Constitution. So I got a slide here that talks about the more perfect union. I've talked about that to some degree. They were revising the earlier Confederate form of government, which was a very bad form of government. The Confederate form of government was seen as dangerously inadequate. In what way? It did not provide for the common defense, especially It did not establish justice. It didn't ensure domestic tranquility. People would be looking out after their own interests and fighting for their own. It didn't provide for the common defense. And it didn't secure the blessings of liberty to them or their posterity, they felt. So, as bad as they hated being under England's wrath, they knew that they didn't want to be under a government which was no government at all, that had no ability to provide anything. Because if you're going to have a government, it has to be able to do certain things. And so they were seeking to change that process by creating a constitution. And in doing so, they had to make compromises. And unfortunately, one of those compromises, the compromise to allow slaves to continue to be a factor in the southern states, led to the Civil War. It did not provide for the common defense, didn't do all these things. They hoped to make a union of states that was better. To a certain degree they did, but it was a compromise document, as I said. The compromises, well, there are many of them. Things that you might not realize are compromises. Privileges and immunities. The Bill of Rights that was tucked on there. States were not bound to protect these only. They were not bound by these. Only the national government was confirmed and restrained by them. So the 10th Amendment reserved certain unnamed rights to the people, or, confusingly, to the states. Rights. States have rights. Does the national government have rights? Why do the states have rights? It seems rather odd. When the English sued their king to have rights, did they talk about the rights of the king? No doubt he had them, right? Sovereign rights. Okay, so they had sovereignty. Is that their rights? Or is that just something that's necessary to give them in order to have them? Well, the full faith and credit clause also applies only to civil matters. So states were not necessarily bound to recognize criminal proceedings from one state to the other, not in its early days. And actually in the South, there were lots of persecution if a northerner went to the South and did something that was, they thought, offensive to their culture. He was going to be in big trouble. So his rights would be traversed. Only bound to recognize other states' contracts, wills, deeds, and similar documents. That's about the extent of full faith and credit clause. They were recognizing your deed to land. They were maybe recognizing your contract and similar documentation. They would recognize bills of exchange, bills for money. Separation of powers. The early president largely ignored the Supreme Court rulings. So Jefferson didn't pay much attention. Jackson basically violated a Supreme Court ruling that said that the Indians had a right to stay in their southern states, Instead, he forced them on a march to Oklahoma Territory. It's called the Trail of Tears. Terribly awful travail for those indigenous people. So he forced them to along the Trail of Tears. The national government had very little express powers to spend for the general welfare. Okay. This was changed by an expansive interpretation of the Commerce Clause in 1936. So you find before 1936 the ideal that the government ought not to be too big, being a very general ideal. We still have this ideal amongst many people today, but certainly the government did get big. In 1936 it needed to get big to handle the Great Depression, and that was the only way really the Great Depression got solved. The countries that were first to adopt it, such as Sweden, Japan, and other countries, and even Germany, were quick to adopt this spending that was necessary to get them out of the Depression. You know, they basically, now, you know, actually Germany had gone through a phase where it was spending too much, actually. But with responsible spending, there's a way to get out of depressions. Anyway, privileges and immunities and Bill of Rights didn't bound them. Full faith and credit clause was very limited. Separation of powers, the early presidents largely ignored the Congress and the Supreme Court. The national government had very little express powers to spend for the general welfare. This was changed by an expansive interpretation of the Commerce Clause in 1936, which is now under attack. The improvements. Congress has the power to regulate and govern military forces and militias, suppress insurrections, and repel an invasion. And there's an implied power in that to fund an army, so there's a necessary and proper clause. If you're going to have an army, then it's necessary and proper that you be able to fund it, which would mean that you could somehow express, you know, get import duties, or you could maybe tax. You know, there is a provision in there, the government can tax and spend. So the tax and spending clause is there, but it's a very limiting provision. You know, it says that the taxes have to be equally divided amongst the state, and very little else. So, I mean, in many ways, the Constitution is a very short document for what it's doing. But all it's doing is quite immense. Commerce Clause is often paired with the necessary and proper clause, and the combination used to take a broad, expansive perspective of these powers. However, its effectiveness varies depending upon the Supreme Court's interpretation at the time, but also depending upon, I think, who's in power. So during certain presidents like Washington, Lincoln, and Roosevelt, you saw an expansion of government, where government was doing more for people, which meant taxing and spending. The people were happy with those governments. As a matter of fact, the Supreme Court was constantly, invalidating the New Deal legislation, and I think they thought that the people would support that. And in fact, they found out that the people overwhelmingly supported FDR's New Deal program, which in 1936 led to a change in how the Supreme Court was ruling. So Chief Justice Hughes and Butler were two justices that switched their vote. Some people talk about it being Butler who switched, but I think actually Hughes actually was oftentimes with the Four Horsemen, they were called Four Horsemen of the Apocalypse, and they were just basically ruining the New Deal programs and causing the country to slip more and more behind. Commerce Clause, so however, yeah, okay, Supremacy Clause and the Federal Preemption Clause are also improvements. They gave the people power, they gave to the Congress, which works for the people, the power to remedy mischievous state laws. There was reluctance to do that, and there still is. And somewhat, there's some sense in that, because state laws are oftentimes passed by state legislatures, and therefore they are also a voice of the people. But, you have to consider that the Congress of the United States is also a voice of the nation. And as between a subordinate branch of government and the supreme branch of the government, then it has to be that the supreme branch has to have the ultimate authority. And that's what the final clause I want to mention that's an improvement was the Supremacy Clause. And it gave the federal the right to make the law, and even something called federal preemption. So federal preemption was an improvement because it was basically the power of Congress to write laws, and its laws would be supreme, and therefore any state law that conflict with it actually would have to be stepping down, and taking a back seat, or maybe not enforced at all. So, that's the federal preemption that arises out of the Supremacy Clause. gave the people power to remedy mischievous state laws. But we talked about mischief and interpretation. When you're passing legislation, so one of the things you want to look at is what is it, the mischief that you need to remedy, because you're not just going to be passing legislation for no reason. You need to have some mischief that you're addressing. And so that's what we expect from our legislators, whether it's Congress or state legislators. Supremacy clause in federal preemption. The Constitution and laws of the United States which shall be made in pursuance thereof shall be the supreme law of the land, and the judges in every state shall be bound thereby. And so these are the words of the Constitution. That's Article 6, Clause 2. In Federalist number 33, Alexander writes, if individuals enter into a state of society, in this case individual states, they're entering into a government, right? They're forming a government. The laws of that society must be the supreme regulator of their conduct. So basically the laws of that government that's representing all of them must be the supreme thing. You know, they're entering into it a reason. They've got to become a unit, so they have to work all together. And to do that, they need to have some leadership. And hopefully they will elect people who can lead them. They chose a very good one when they chose Washington. He was liked by everybody, and everybody admitted he was a very virtuous man. They didn't always choose the best person for his job. They chose another good one when they chose Lincoln. And, you know, I think they chose another one when they chose FDR, Franklin Delano Roosevelt. These three are highly weighted by all historians. You can look at what happened during their administration, and you can see that the nation made real progress while they were there, improved. And so that's one way of looking at things. Okay, so Supremacy Clause and preemption. Federalist number 33, Alexander Hamilton, I already read that. You know, now let me read Madison. In Federalist number 44, James Madison defends the Supremacy Clause as vital, having the federal government subservient to various state constitution would be an enormous inversion. It'd be flipping it, it'd be 180 degrees opposite of what it should be, right? An enormous, you know, inversion of the principle of government, concluding that if supremacy were not established, it would, that's just how he concludes, it would, in this quote, it would have seen the authority of the whole society everywhere subordinate to the authority of the parts. It would have seen a monster in which the head was under the direction of the members. Not a very good kind of way of organizing. And he mentioned that if, in fact, I think it was him who mentioned if, in fact, a state could succeed, because this issue came up even as early as the drafting of the Constitution, whether states should have a power to secede. It was rejected. Why? Because, you know, what's the point of joining just to have it do it? And if you can succeed from the national government, then what's to stop the cities and the counties under which, you know, which are your parts, your members? What's to stop them from seceding? Or what's to stop individuals saying, well, I'm just going to secede? Well, individuals could maybe do that easily back then, but certainly you wouldn't want to have the government breaking apart so easily like that. And so this ideal was soundly rejected by the Founding Fathers, which is why they built the Constitutional Supremacy Clause and preemption and made a strong central government. Now I'm going to talk about the case of Cooper versus Aaron. In Cooper, the Supreme Court nullified attempts by Arkansas to nullify the court's desegregation decision. So basically, we come forward into the future and there's Brown versus Board of Education. Arkansas, acting on a discredited theory of states' rights. States' rights is a very divisive kind of theory. It's like, well, states can do whatever they want, and the government is subservient to them. That's not a very good organization. That the Arkansas, acting on states' rights, had adopted several statutes designed to nullify this desegregation ruling. Okay, the states retain only police powers that have not been preempted. In other words, any law of the United States under the Supreme Court, any law of a state under the Supremacy Clause, if it conflicts in any way with the federal law, it's nullified. It's preempted. This broad federal preemption power covers past, present, and future assertions of state legal authority. So they can't say, well, that was in the past, but this is now. No, the federal government can preempt all of their decisions. And applies to states' constitutions, to its statutes, to its judicial decisions and precedents, and also to agency rules and regulations and all acts of any state entity. However, of course, it's understood the government will only operate this power within reason, so they shouldn't be just simply doing things just because they can't do it, certainly. And I think our governments have generally been that way. I don't think that they have been as bad as some people like to portray it as being. Anyway, Crosby versus National Foreign Trade Council. This is also a relatively recent decision, more recent than that one. That one was from the 1950s. This one is from the 2000. Held that even when a state law is not in direct conflict with a federal law, the state law could still be found unconstitutional under the Supremacy Clause if the state law is an obstacle to the accomplishment and execution of Congress's full purposes and objectives. Congress need not expressly assert any preemption over state law either, because Congress may implicitly assume this preemption under the Constitution. Now I'm going to give you a little bit of history here. The power to govern has cycled between two poles, if you would. One is federal power, nationalism. The other one is white power and states' rights. And I actually did that on purpose. I said white power, I meant white power, because there was a racist element in our nation which has always been associated with states' rights. As a matter of fact, it's now considered to be a code word for racism. Federal power basically is nationalism and a united sovereign. Washington, Hamilton, and his men from his army all believed in that very strongly. And one of them wound up, John Marshall wound up on the Supreme Court. And you look at his decision and you can say, yes, he was interested in promoting the national interest. And therefore, some of the people who were in state governments were upset with some of his decisions, but they couldn't do nothing about it. And even after Jefferson and other anti-federalists had come into power and began to appoint people who were less nationalistic and more interested in states' rights, he continued to persuade those judges to rule his way. So he was quite a fellow. Anyway, so United Sovereign, 1789 to 1835, Chief Justice Marshall's era. McCulloch versus Maryland involves the Supremacy Clause, denying Maryland the right to tax the Second Bank of the United States. They were opposed to the Second Bank of the United States because they saw it as a national institution that would strengthen the national government. Well, by golly, that's what they needed, right? And the Second Bank of the United States paid off all of the war debt, something that states couldn't do and wouldn't do. It managed to pay off all those debts. And that created a lot of credibility in the United States. If it wanted to borrow money from the European powers, it could borrow money because they knew it was good to pay. And this was part of the genius of Hamilton. And then after Marshall's era on the Supreme Court, you then have the dual sovereigns, 1836 to 1864, Chief Justice Taney's era. And basically, he would argue that, well, we have dual sovereignty. He did concede that the national government was sovereign, but he tended to stress the sovereignty of the state governments, which is why, of course, Jackson appointed him to the Supreme Court. And then I think under Lincoln, we began to get a more active government, and part of that was the Supreme Court 1864 to 1877, Reconstruction and Civil War amendments. Congress was empowered, and the Supreme Court wasn't overruling it. And then there was a change in 1873, I think, 78, 36, the Robert Barron era. You have decisions like Hammer versus Dagenhart denying Congress the power of police powers. You know, they don't have any police power, so they couldn't make any laws according to Hammer versus Dagenhart when it came to what's called power versus police power. This ideal is not dead. Matter of fact, in 2000, Rehnquist wrote an opinion, and he got 5 votes to support himself, that, you know, basically was along those lines, saying that it's not up to the national government to make laws. And you see it also recently under our current Supreme Court, and when they threw out the case that was was helping out the enforcement of protection of women under the Women with Violence Act, which was thrown out basically on the ideal that the federal government didn't have police powers. And, you know, if it had police powers, it would be supreme, right? And so the only way for people who are for states' rights to overcome that supremacy clause was to ignore the fact that state police power is not really something that has been recognized in the past by the most successful courts. And so in 1970, we had originalists, and so they took over. But from 1937 to 1970, you had the New Deal, Brown versus Board of Education in the 56, and right on up through the 70s, I think you had a court that was more friendly. And it continued maybe even longer than that when you look at it, that there were very persuasive, very bright liberals on the court that managed to continue to frustrate conservative plans to limit the power of government and to make government just simply a non-entity and ineffective. States' rights as a code word. Racists have used the term states' rights as a code word for a long time, or as a dog whistle, that is, sending messages undetectable to the general population, but has specific resonance for a targeted subgroup. So there are all other code words too, but states' rights is a code word. George Wallace declared in 1963, segregation now, segregation tomorrow, segregation forever. He did this when the federal marshals were basically desegregating the schools, and he stood in the doorway of the school and had to step aside and had to submit because of the power of the federal government, because President Eisenhower supported that decision. Although he didn't like the decision, he had told, you know, that you really shouldn't have done this. I believe he had told the Supreme Court Chief Warren Burger, not Warren Burger, I'm sorry, previous, you know, he had told the Supreme Court that it was a bad idea somehow. I think he maybe did it indirectly through somebody. Maybe he told somebody and they do it, but he didn't like the idea. Later, Wallace stated he should have said states' rights now, states' rights tomorrow, states' rights forever, which is a more broad term. It has the same sort of effect. He was claiming the state right not to have the school desegregated, you know, and to have actually no integration. And so it wouldn't have happened if, in fact, there was anything really to the state rights thing. It's not a very good policy, and it's been usually something that the racists have tried to use to basically restrict the federal government. In 2010, some claim that Texas Governor Rick Perry's use of the expression states' rights was reminiscent of an earlier era when it was a rallying cry against civil rights. And so this was big hue and cry, and he eventually came out and said he was not for racial segregation, and you know, sort of kind of denied that he was actually appealing to white power. But what do you think? Was it a dog whistle? 14th Amendment. there's the citizenship clause in the 14th Amendment. So the citizenship clause, and its 14th Amendment was what was called part of the Reconstruction Amendments. So this was at a time when Congress was still being controlled by Northerners, and the Northerners were very sympathetic and wanted Reconstruction to succeed, especially at that time because they had lots of veterans who had fought to keep the southern states in the Union and to free the slaves. It became more and more to free the slave as the war went on. There may have been many of them that thought they were fighting to keep the Union together, and realized at some point that there was more at stake than that. There was a moral issue. I think this was true of Lincoln. If you look at his speeches, that he seems to evolve in his approach to the whole thing. And with his evolution, either he was moving with the people or he was moving the people. I don't know which. You find that going on. So, privileges and immunity clause. The due process clause, privileges and immunity clause would, the citizenship clause of the 14th Amendment basically declared that the recently freed blacks were citizens, which had been denied by the Taney decision, Chief Justice Taney, who had declared in his famous Dred Scott decision that blacks had no rights that a white man needed to respect, and that blacks were something less than human beings, basically. He didn't actually say what they were, but he said they were just not the equivalent of human beings. And it's caused Lincoln actually to say something about, well, he was not necessarily for blacks, because at the time when he was running for election, he probably would not have gotten as far as he did had he come out, because many Northerners in the North we would now call racist. And he said he didn't favor the blacks, but as between a white person and a black person, he didn't favor the black people. But he then said that as between the alligator and the black person, he doesn't favor the alligator; he favors the black person. And so, one of the things that he was opposed to was the Dred Scott decision. Anyway, he said it was an awful decision, equating them to be some sort of animal. And that's how they had treated them, right? Like some sort of cattle, some sort of possession. So there was also the due process clause that then also was there to protect the blacks. So due process clause and privilege and immunity clause was protected. They were going to get due process in the courts and be treated as equal. Didn't happen. At least it happened initially, as long as there were federal troops down there, you had some reconstruction because the federal troops would enforce the laws. But when they were pulled out in 1873, because of a change in the environment, in that there had been a depression and a run, and there was economic hardship, and it was hard to keep paying people in the South when the Southerners didn't want them. And so there are all kinds of problems. Equal protection clause is also in there, so they would be given equal protection under the 14th Amendment. And nowadays, oftentimes, when you say 14th Amendment, people immediately think of the equal protection clause. So this is what's used in terms of whether or not LGBTQ people have any rights. Well, yes, they do, and they have it under the equal protection clause, don't they? But the thing about it is, it doesn't come from the 14th Amendment. Actually, although that's sometimes cited, is actually they get it through the acts of Congress and the Commerce Clause. So and so this is why you see, if you pay attention to the Supreme Courts, some of the people on the Supreme Court are attacking the Commerce Clause because it's a way of getting around the overruling of the 14th Amendment by the Supreme Court that happened in the 19th century and remains precedent, and it was cited by Justice Rehnquist in 2000 in his decision and for his view of federalism, which is the states' rights view of federalism. The Equal Protection Clause comes in there. So that's what we should be actually basing these decisions on. And that's what people think it is, but actually it's coming through a back door. Congress shall have power to enforce this article by appropriate legislation. So all the Reconstruction Amendments, the 13th, 14th, and 15th, all of them had this clause that Congress could enforce the clause, because that would have been disputed if they hadn't. They needed to give Congress that power in an amendment, because there's a claim that the Constitution set up a very limited federal government. But here they're given power to enforce the Equal Protection Clause. So they can make laws to do that. There's no doubt that they have that power. And when they exercise that power, they can preempt any state laws. Heart of Atlanta Motel Incorporated versus United States, 1964. Although the Civil Rights Act of 1875 was held unconstitutional, and it was based on the 14th Amendment, which was also declared, well, it was made a nullity, really, by the slaughterhouse cases. Unconstitutional. And the civil rights cases of 1883. The Civil Rights Act of 1964 was upheld as constitutional. So the reason for this 1875, what did the 1875 Civil Rights Act do? Well, it made public accommodations available to black people. And this was very much resisted in the South. And so what did the Civil Rights Act of 1964 do? Well, it made public accommodations available by law to blacks and other individuals, to every individual, every person, and you know, to every citizen. And blacks are defined by as citizens by the 13th Amendment. And involving, you know, the 1964 Act was upheld as constitutional, and it involved public accommodations. The same thing as had been thrown out before. Now justified, the power to do this was now justified under Congress's Commerce Power Clause, the fact that they can regulate commerce. So you have these people going down to the South, they want to stay in a hotel, and so they're told in the Heart of Atlanta Motel that they can't stay there because they don't take their kind. And they can say, well, you have to let us in because of the 14th Amendment and the 1964 Civil Rights Act. And so they had to give way. So that was a major case, basically validating the 1964 Civil Rights legislation, which includes actually the Equal Employment Opportunity Act, which was part of that major legislation, as was the Housing Act and other legislation. There's all a big bundle of acts in 1964 that was passed, which had been successfully defeated for years by the Southern Bloc of states. Anyway, Griggs versus Duke Power Company. Title VII of the Civil Rights Act of 1964 was upheld as constitutional, in this case involving employment discrimination. So this is a case that upheld the power of Congress to pass the Equal Employment Opportunity Act. It involved an IQ test, which was used as a means of denying a transfer to an African American. So he wanted to transfer to another part of the plant where he worked. And he worked in a factory. There was another division that he could make more money in, and he wanted to do it. And you know, he didn't do very well on IQ tests. Many blacks generally didn't do well on IQ tests. IQ tests are not actually a test of general intelligence. This was something that was oftentimes spread by psychologists, but in fact it was not a test of general intelligence. What it is, it shows preparedness to perform in an academic environment. If you have a high IQ, you can do well in an academic environment. Doesn't mean you can create a great novel, doesn't mean you can create anything at all. Doesn't mean you can be an effective manager. That's not what an IQ tests. It tests just simply your ability to manipulate words and numbers. It's primarily what it does. And so the court said the IQ test was not the proper means to be given for determining whether or not somebody would be employed or get a transfer or get a job. United States versus Harris. The 14th Amendment was also held to be unconstitutional. United States versus Harris. in 1883, which declared that Congress had no power to interfere with police power of the states. Basically, that decision says that it was another decision where they said, well, the federal government doesn't have any police power. So the police could ignore the fact that these inmates were actually lynching a black man in a cell. And, you know, although they should have been able to control that situation, they had everybody locked up, they chose not. It looks like they didn't choose to do it. And they said, well, since there was no state action, the government wasn't involved, and that this was done by private parties, actual prisoners who were under the control of the police. There was no state action, and therefore you have the state action doctrine. You can't assert rights under the 14th Amendment or the Civil Rights Act unless, of course, there is state action. So, yeah, and we still have that doctrine today. Still, it's being ruled on and followed. So that was United States versus Harris. Rationale offered in majority by Morrison. United States versus Morrison was a case that did away with the Women's Violence Against Women's Act, and so they did it away. What did they say when they did away with it? The majority held that Congress lacked the power to enact Violence Against Women Act under the 14th Amendment, relying upon state action doctrine. Okay, the same thing as they'd done with Harris. So is our court today any better than our 19th century court, which was basically allowing prisoners to be hung by other prisoners when they were in jail? So they were in prison, and you know, nowadays, of course, we say the police have to make an effort to protect that person. They were making no effort back then. This doctrine, which was originated in the United States versus Harris and the Civil Rights case of 1883, provides that the prohibitions of the 14th Amendment do not apply to private individuals. Because the Civil Rights Act of 1875 applied to racial discrimination in private establishment, the court said in the civil rights cases it exceeded congressional enforcement powers. So it says the civil rights cases proceeded because they were actually requiring private establishments to comply with federal law. So it goes back to whether or not the federal government has the power to pass laws. That and you know, they do have the power under the Commerce Clause, is what they held back then. But we're seeing that attack now. That cases are being determined by conservatives on the court who are saying that the Commerce power doesn't provide that power, and that may change things quite a bit. And you know, are they going to recognize it when Congress overrules them? Are they going to do what the Supreme Court did in 1936, was certain conservatives changed their view after an overwhelming victory by Roosevelt, who had threatened to expand the court to 15 justices, to pack the court, and they basically, two of them decided that, you know, they wanted to recognize this New Deal legislation as being valid. And the court said in civil rights cases it exceeded congressional enforcement power under the 5th of the 14th Amendment. So it said that basically the Congress had no police powers. A common theme. Dissent in Morrison, in dissent, four of the justices argued that the majority was relying upon old, discredited interpretation of the Commerce Clause, and not the courts to limit Congress's. It's not up to the courts to limit Congress's power under the Commerce power. That's up to the Congress determines its power. You know, yes, the court can rule upon the Commerce power and interpret it, but they can't change its wording, can they? The States' Rights Doctrine did not diminish the Commerce power as a source of congressional power to protect them. So there was some leftover power that wasn't given to the federal government, that goes to the states or the people. Kind of dumb idea, I think, for states to have rights and powers. Well, I can understand them having sovereign powers, but certainly they shouldn't be overruling what the nation wants. You know, so I'm not going to. I have something here about a historian who says that Morrison is being used to undermine hate crime statutes. He was afraid of that. I don't think it has been used that way. Maybe because he pointed out that that's something that maybe they're going to do. Maybe they're going to wait till after the election. First Amendment. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press. So I'm including in here the actual words of the Bill of Rights so people can see them. Or the press, or the rights of the people peaceably to assemble and to petition the government. And as long as we just follow what the words say, I think that, how do you know whether or not somebody's violating the First Amendment? Well, is he saying something that's endangering people? We give a good deal of freedom to say, for people to say in political speech anything, but there is some limit to how far they can go, and if they're going to be putting people in danger, that's another story. But it has to be real, and it's not just doesn't have to be something that somebody claims when there's no evidence to back it up, which we've seen a lot of. The Fourth Amendment, the right of the people to be secure in their persons, house, papers, and effects. So this guards you in terms of your being searched, in your car being searched. You have a Fourth Amendment right not to have to, open up your car. You can say, no, I'm not opening my trunk. They have to then get a search warrant to open your trunk. So they can do that, but it takes time, and you don't have to actually do it. So you have a Fourth Amendment right to protect your privacy in the home and in your car and on your person. They can't search you for papers. They can't open up your briefcase and go through it without you getting permission from you. So don't give it to them. And then, if your wife has died, whether you know it or not, the police will have you as a suspect. And so they'll want to search everything, looking for something to pin the case on you, because there's just this automatic suspicion that it's usually the man or the woman in some cases. Fifth Amendment, no person shall be held to answer for a capital or otherwise infamous crime unless a presentment or indictment. So Fifth Amendment gives you a lot of criminal rights. Gives you a right to grand jury, and gives you a right to life, liberty, and property. So you can read these on your own. The Sixth Amendment also provides a lot of criminal protections. Gives you a right to enjoy the right of a speedy and public trial, an impartial jury, and in the district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation. That's due process, right? Minimal due process requires them to tell you that. To be confronted with the witnesses, so you have a right to confront witnesses. You can challenge them. They have to look you in the eye and say what they're saying. And to have compulsory process for obtaining witnesses, so you can get a subpoena for witnesses. You can get a subpoena for hard evidence. Seventh Amendment. The Seventh Amendment gives you a right to trial by jury in a civil case. So the right to trial by jury in the Sixth Amendment only applies to a criminal case. Fifth and Sixth Amendments are criminal law protections that citizens have against unfair prosecution. And no fact tried by a jury shall be otherwise re-examined by any court. So here in the Seventh Amendment it says that the jury determines the facts. If you ask for a jury and have a jury, the jury gets to determine the facts. One fact is, are you guilty or not? That's a fact. If the jury finds you legally guilty, you're legally guilty. If the jury finds you not guilty, you're not guilty. No matter what anybody thinks. Well, it doesn't matter what the judge thinks. He can't, the most he could maybe do is to call for a new trial. And he's not going to likely do that unless there's some sort of terrible thing happening. Thank you very much for everything, and we'll see you next time.